Good morning, Mr. Chairman, members of the board, members of the public who are in person and watching on Charm TV. The May 22nd proceedings of the Board of Liquor License Commissioners for Baltimore City will now begin. Please take this opportunity to turn off or mute all electronic devices. Don't be that person whose phone goes off in the middle of the hearing. The board is now in session. Mr. Chair, there are just a few preliminary matters. As always, the list of hearings to be heard today, and the front row. The list of today's hearings and the docket are on the door. If you haven't already, just check to make sure the hearing you are here for is scheduled to be heard. There are 3 cases that are postponed. Case number 4 on the docket, Grace Pilot, Jacobson, Pusser's Landing, Canton, LLC, trading as Pusser's Landing, 2711 Boston Street, amended application to transfer ownership. Case number 13 on the docket, Ho K. Lawler, HBS Enterprise, Inc., trading as Sugar Hill Tavern, 2361 Druid Hill Avenue. Violation of Rule 4.20B. And then case number 15 on the docket, Nebiu Seyum, Hideout Liquors, LLC, trading as Hideout Liquors, 2101 through 03 East North Avenue. Violation of Rule 4.204B. Violation of Rule 3.052. And violation of Rule 3.02A. All right. In accordance with Section 12-2105A of the Maryland Alcoholic Beverages and Cannabis Article and Liquor Board Rule 2.16, the following licensees have participated in the monetary penalty in lieu of hearing program by voluntarily admitting the violations as charged and paying corresponding fees in the following case. And Anania Fantanum, I apologize if I mispronounce it, Ayel McDiam, Annex LLC, trading as Annex Lounge, 1818 Maryland Avenue, Class B beer, wine, and liquor license. Violation of Rule 4.14, live entertainment without authorization. Violation of Rule 3.081A, sanitation and safety. Violation of Rule 3.09, restroom facilities and health regulations, and paid a fine of $1,500. All right, now we're finally into the docket. 90-day transfer hardship extensions. Case number 2, Surendra Panjade, Pradpedeep, LLC, trading as Jerry's Liquors, 2200 North Charles Street, Class A, beer, wine, and liquor license, request for transfer hardship extension under the provisions of Alcoholic Beverages and Cannabis Article Section 12-1705B. Please come forward.
Good morning. Stephen W. Fogelman on behalf of the applicant.
Good morning. We have your letter, Mr. Fogelman. What's going on?
Just trying to get a final building inspection, and he's running out of time. So we're hoping to get that in the next week and a half.
All right, commissioners have any questions?
No questions.
All right, thank you. On the basis then of the written request dated April 21, 2025, and the proffer this morning, vote to approve a 90-day transfer hardship extension for this Class A beer, wine, and liquor license.
Yes, based on materials, letter from the attorney, and testimony, I also vote to approve the request for transfer hardship extension of 90 days.
Based on your April 21st letter and your proffer made today, I also vote to approve this 90-day transfer hardship extension.
Ms. Russell?
No exhibits for the record.
Thank you.
You're welcome.
Gurdeep Singh, Sun Inc., trading as Sun Tavern and Liquor Store, 310 North Utah Street, Class BD7 beer, wine, and liquor license. Request for a transfer hardship extension under the provisions of the Alcoholic Beverages and Cannabis Article, Section 12-1705B. Please come forward.
To another. They're waiting for the final approval and sign-offs to get their UNO. They're having some problems with the building department, but they hope they'll be able to clarify that in the next 90 days or so.
Okay. Commissioners have questions?
No questions.
No questions.
Okay. Mr. Knansky, on the basis then of your written request of May 2, 2025, and your proffer this morning, vote to approve a 90-day transfer hardship extension for this Class BD7 beer, wine, and liquor license.
Yes, based on materials and letter from the attorney, I also vote to approve the request for transfer hardship extension of 90 days.
Based on Mr. Kudinski's May 2nd letter, the proffer made today, also vote to approve this 90-day transfer hardship extension of this Class BD 7 beer, wine, and liquor license.
Ms. Russell?
No service for the record.
Thank you.
Timothy Langford Condor, 1502 Clipper Road, LLC, trade name pending. 1502 Clipper Road, Class BD7 beer, wine, and liquor license. Application to transfer ownership and location of a Class BD7 beer, wine, liquor license presently located at 1014 West 36th Street to 1502 Clipper Road, requesting outdoor table service. Please come forward.
Yes, good morning. Stephen Fogelman on behalf of the applicant, Timothy Condor, who's here to my right.
All right, Ms. Fogelman, do you want to proffer for us?
Certainly. Mr. Condor stands before you. He is a 30-year resident of Stone Hill in the south part of Hamden, 30-year city resident, was majority owner of Hamden Yards in Hamden without, as far as I know, any violation history. He is opening up or, attempting to open up here this space at 1502 Clipper Road, down right facing the Jones Falls, right at 83. He is, the concept here is going to be a casual lounge. It's got some roll-up doors, community hub. People can come in, bring their laptops, can get some work done, have a beer. He's going to have a small selection of Maryland and local Baltimore tapped beer, wine, a little bit of liquor. Nothing, not really craft cocktails or anything like that to start. There is plenty of parking at the establishment. Mr. Condor, in addition to running Hamden Yards, runs Charm City Crewing Company, doing corporate events, and even owns a miniature golf course in Carroll County. He is alcohol management certified, and his employees will be as well. He only anticipates about 3 employees beyond himself.
And when perhaps will it be open?
Let me find out. Fall 2025.
Commissioners have questions?
No questions.
No questions.
All right, thank you.
Thank
you. Anything further, Mr. Fogelman?
No, thank you very much.
Based on the materials contained in the application, the proffer from council, I vote to approve this application to transfer ownership and location of this Class BD7 beer, wine, and liquor license presently located at 1014 West 36th Street to 1502 Clipper Road with outdoor table service.
Yes, based on material, a letter from the attorney, and testimony, I also vote to approve the application to transfer ownership and location of a Class BD7 BWL license presently located at 1014 West 36th Street to 1502 Clipper Road, and a request for outdoor table service.
Based on the application materials and the proffer made by council, also vote to approve this application to transfer ownership and location of this Class BD7 beer, wine, and liquor license presently located at 1014 West 36th Street to 1502 Clipper Road with outdoor table service.
Thank you.
No service for the record.
Good luck, sir.
You can see Mr. Ramsey in the back for your slip.
Sung Cho and Nicolette P. Basilari, Fort River Inc., trading as Outpost Tavern, 1030 to 1032 Riverside Avenue, Class BD7, beer, wine, and liquor license. Request to add outdoor table service. Please come forward.
Mr. Wallman, good morning.
Good morning, Mr. Chairman. Joe Woolman, Silverman Thompson, on behalf of the applicant.
You want to proffer for us?
Certainly, thank you. This is a rare treat for me. I get to represent my neighborhood tavern and restaurant. I live about a block and a half down the street, Riverside Avenue, which is a street I know Councilman Reisinger is very familiar with, having, I believe, grown up on that street, if I'm not mistaken. To my right is Nicolette Basilari. She's the manager of the Outpost Tavern. The Outpost has been there for a long time, and during COVID had outdoor tables. There was some confusion as to the permitting for those, and we've gone through quite a lengthy procedure, including appearing before the zoning board last month, where I'm glad to report that after appearing before the zoning board for probably over 20 years, I've never had a case with so much neighborhood support. We had 127 letters of support at the zoning board for the outdoor table service for this establishment. It was certainly unprecedented in my career. We've obtained a minor privilege permit from the Department of Transportation for the placement of these tables and received a temporary extension. Pleased to report that the tables have been outside in the last couple of weeks. Pursuant to that, the neighborhood is thrilled to have the outdoor seating back in the neighborhood.
Apparently, there's one neighbor who's not. Have you seen this?
I have. He also has submitted a letter to the zoning board for that hearing and did not appear at that time. But yes, I believe he lives on Cross Street, if I'm not
He gives
mistaken.
an address on Riverside
Oh,
Avenue.
yeah, I'm mistaken.
Is Mr. Hosey present here today? Okay. You haven't had a chance to speak with him?
I haven't. I thought I'd meet him at the zoning board hearing, but he didn't appear.
But you had no other opposition. There was a violation of this recently at this location.
I believe it was related to the tables being outside, and that led to all the steps we've had to take to rectify the situation, yes.
How many tables are we talking about?
5,
Okay, with how many customers?
4 each.
And you understand that they need to be seated at the tables and not gathered in crowds outside and all that. Okay, do the commissioners have questions?
No question.
No questions.
All right, I'd recommend to you, is it you, Ms. Cho? What is your first?
Vasilieri.
Vasilieri, you're the other licensee. That you at least attempt to contact this gentleman and have a conversation with him so you don't have someone pestering you the rest of the time, or have Mr. Wellman do that. See if you can reach some kind of a
Understood.
resolution with him. All right, on the basis of the materials contained in the application, the proffer from counsel, and any testimony received, I vote to approve this application, or this request to add outdoor table service to this BD7 beer, wine, and liquor license.
Yes, based on material, testimony provided today, I also vote to approve the request to add outdoor table service.
Based on the application material, proffer made by council, any testimony given today, I also vote to approve this request to add outdoor table service to this Class BD7 beer, wine, and liquor license.
Ms. Russell?
Michael Exhibit for the record, Board Exhibit Number 1, letter of opposition dated 5/20/25.
Good luck, ma'am.
Thank you.
Mr. Woolman, you can see Mr. Ramsey in the back for your slip.
Jason Bryce Thomas and Benjamin Attar, Striclops LLC, trading as Night Shift, 1725 South Ponca Street. Class BD7 beer, wine, and liquor license, and Class AE adult entertainment license. Application to transfer ownership of both with continuation of live entertainment. Please come forward.
Morning, Commissioners. It's a new space. You're lower now than before.
Yes.
If I may proffer, Mr. Attar is continuing on
You
as
identify yourself for the record.
Abraham Hurdle for the Striclops, I believe, LLC.
Thank you.
Mr. Attar is continuing on as a licensee. My client is taking over. There's going to be a new business operation there. Right now, one of the things that my client's been looking into is there's a lot more food that they're doing than they anticipated. They actually do a lot of DoorDash and Uber Eats. We're looking to expand the lunch operations in terms of food aspects. I know there have been some issues in the past. They're working with Jimmy Philippidis on underage service issues. They're talking to a new security company to make sure that there aren't any issues in the parking lot or at the establishment going forward. The operations should otherwise continue on very similar. They're doing a lot of kitchen renovations to keep things. Again, food seems to be a larger part of the business than is anticipated, so I'm going to play into that a little bit. Otherwise, this is a location that's kind of off the beaten path in the Canton area. Generally, the operations won't change again, besides the stronger focus on food. If the board has any questions, we'd be.
What kind of food?
I think it's going to be mostly tavern food, burgers, pizza, things of that nature. Again, that seems to be what's selling very well on Uber Eats and Grubhub and so forth. We do plan to add delivery, I think, at a later time. I don't think it was on the application.
Commissioners have questions?
No question.
All right, thank you. Based on the materials contained in the application and the proffer from council, I vote to approve this application to transfer ownership of this Class BG7 beer, wine, and liquor license and Class AE adult entertainment license with the continuation of live entertainment.
Yes, based on material and testimony provided today, I also vote to approve the application to transfer ownership of a Class BD7 BWL license and a Class AE adult entertainment license with continuation of live entertainment.
Based on the application materials, the proffer made by council, also vote to approve this application to transfer ownership of this Class BD7 beer, wine, and liquor license and a Class AE adult entertainment license with the continuation of live entertainment.
Mr. Russell?
No exhibits for the record.
Thank you, Commissioners. May I be excused?
Yes.
Thank you.
Okay, moving into the violation section of the docket. Anania Fantanum and Ayel Mekdiem, NX LLC, trading as Annex Lounge, 1818 Maryland Ave, Class B, beer, wine, and liquor license. Violation of Rule 4.14, live entertainment without authorization on April 26. Violation of Rule 3.12, general welfare on April 26, loud music. Violation of Rule 3.092, restroom facilities and health regulations on April 26, which was a violation of Baltimore City Health Code Section 9-3062, little I. And finally, violation of Rule 3.082, sanitation and safety on April 26 for failing to keep garbage containers covered. Please come forward.
For the record, Melvin J. Kadensky representing. These are the people who were taken over and was approved, and I'll explain to you the situation.
They were also the folks who entered into the voluntary payment on the first case, right?
Yeah, and they really shouldn't have done that, but I'll explain how that happened. Not that it's any excuse, but and we're going to go ahead with an admission on this as far as these charges go,
Okay.
and I'll give you by more way of explanation.
You're admitting, go ahead.
This application was approved by the board in February of 2025 to transfer to these gentlemen, and they went in and were operating. They had filed, and it's pending a UNO for the live entertainment.
Let me just ask you, I have on here that the transfer was in 2019.
That's to the current licensee to the new people.
Okay. All right.
The other people were on the license, and they're still on the license. These two gentlemen were approved in February and went in and were starting to do all the things they had to do and had a UNO for live entertainment. Hasn't been approved at this point to the point where they have a UNO. However, they were operating and the place became successful and they had a problem with the garbage and so forth, and they had talked to the neighborhood and they were under the impression they could have a DJ outside. I explained to them they're not going to have any DJ outside. Number two, with regard to the trash and so forth, they've increased the pickup 3 times a week, their pickup, and they're proceeding with trying to get the final approvals, have the license transferred to their names, and get the appropriate UNOs. And you'll probably hear it over. They're having a terrible time getting UNOs. The portals are down, the things are down, but they're very close at this time. The reason why they paid the fine for the owners is because the staff here, rightfully so, wouldn't issue the renewal because there was a fine pending against the old owners. So they figured they took the path of least resistance, although it was $1,500, and they paid it so they could get it renewed to continue operating. That quite simply, and without getting into a lot further, that's the.
So the ones they paid, the violations, they occurred on March 1, and these violations occurred on April 26. When did you get involved?
Me personally,
To tell them that they could no longer have the outdoor,
when I saw these violations here.
so not until after these.
After that, because I think they may have been under the impression since they had an application pending for the UNO, which I gave you, that they could go explain that they can't have it outside, even though they talked to the neighborhood about it.
Can I swear you for just a moment, please? Agent, you just heard the explanation. Are you familiar with any of those facts?
Take mine, we'll share.
Oh, it's working now. There you go. I just would like to note that myself and Inspector Jordan did a walkthrough interview with Mr. Flowers on 2/12/2025, and we advised him that he was not allowed outdoor live entertainment. Mr. Flowers stated that the speakers and the music outside would be for ambient music only.
Who's Mr. Flowers? Oh, but you're not one of the licensees? Are these names the prior licensees?
Yes, they're the
Oh, I
prior,
see.
and they were approved in February, and they took over pending getting the,
Well, I mean, obviously legally, these people are responsible for
they
the
they are
violation.
accepting responsibility.
They are, okay,
And they paid the $1,500 fine
because they want to get the license, but,
because they couldn't get the license renewed to continue to operate.
okay. And what are these gentlemen's names? Mr. Flowers and who else?
Mr. Christmas and Mr. Flowers, it sounds like a good group for a music group. I thought it was Clifton Flowers.
Okay. Did I cut you off?
No, sir.
So you said you explained this to them in February?
We did a walkthrough with them, with Mr. Flowers on 2/12/25, and he answered questions. We had some questions, and one of them was outside. I did explain to him that he did have live entertainment, but it was not for the outside, as I'd noticed speakers outside. And that's when he informed me that the music would be for like brunches, ambient music outside, and he was aware that he wasn't allowed to have outdoor live entertainment.
All right. And you say have they addressed this issue with the trash?
They're having the trash pickup increased to 3 times a week. That should take care of that, and they know they can't do the outdoor entertainment, although they can have inside, and they want to finish this transfer up, but they're having trouble getting all their sign-offs on the UNO.
Commissioners have questions?
No question.
No question.
Further, Mr. Dancy?
No, they're newbies, but they're accepting responsibility. It's not like, they're not in there, and they're in good state with the neighborhood and the community groups that are there.
Okay. I hope that from here on, we have a clean path. On the basis then of the materials contained in the charging documents, the proffer from counsel, which includes an admission of these violations and testimony received, I find a violation of Rule 4.14, live entertainment without authorization, violation of Rule 3.12, general welfare, a violation of Rule 3.092, restroom facilities and health regulations, and a violation of Rule 3.082, sanitation and safety, all occurring on April 26, 2025. I impose a fine of $250 as to each of those violations, and I give you 30 days to pay.
Yes, based on materials and testimony provided today, I agree with the chair's findings of violation of Rule 4.14, live entertainment without authorization, $250. Violation of Rule 3.12, general welfare, with a fine of $250. Violation of Rule 3.092, restroom facilities and health regulations, with a fine of $250. Violation of Rule 3.082, sanitation and safety, with a fine of $250.
Based on the violation report, proffer made by counsel, the admission made today, and testimony given, also find a violation of Rule 4.14, live entertainment without authorization. I find a violation of Rule 3.12, general welfare, violation of Rule 3.092, restroom facilities and health regulations, and a violation of Rule 3.082, sanitation and safety. Also agree with the chairman. And issue a $250 fine with 30 days of pay on all of them. All of these violations happened on April 26, 2025.
Russell?
Consider for the record, Board Exhibit 1, violation report, Agent Tuttle. 2, use permit receipt.
Thank you. Good luck, gentlemen.
Thank you.
Kwang H. Choi, S&K Tavern, Inc., trading as Danny's Lounge, 4316 Reisterstown Road, Class BD7, beer, wine, and liquor license. Violation of Rule 4.20B, prohibited activities by license type. On February 7th, 2025, failing to open the tavern area for on-site consumption when the packaged goods area was open and operating, and violation of Rule 3.052, alcohol awareness certification. On February 7th, failing to provide an alcohol awareness certification when requested to do so. Please come forward.
Good morning, Mr. Chairman and members of the board. Harry K. Previs on behalf of S&K Tavern, Inc. With me is Mr. Kwang Choi, licensee.
Good morning. Will these be admissions or denials?
This will be an admission.
Okay. Would you like to proffer for us?
Yes, Mr. Chairman. The violation for not having the bar area open, it occurred because Mr. Choi, that there's a leak on Reisterstown Road, and there was water emitting through the basement, which affected the HVAC system, and that's why the bar area wasn't open. And Mr. Choi did not have his alcohol awareness certificate at that time, but now does have a new copy.
Okay. Can I swear our person?
I do. Ayanna Bass Myers.
Inspector, were you there at that time?
Yes, sir, I
Were
was.
you given the same explanation at that time?
I was given a similar explanation, but I am inclined to believe it because since I've returned since, and he did indeed have his alcohol awareness certificate, and he showed me that he's making attempts to repair the leak.
So he's been cooperative?
Very much so.
Commissioners have questions?
No question.
No questions?
Okay. Anything else, Mr. Priebus?
No, Mr. Chairman.
All right. On the basis of the materials contained in the charging documents and the proffer from counsel, including the admission of the violations and the testimony received, I find a violation of Rule 4.20B, prohibited activities by license type, and a violation of Rule 3.052, alcohol awareness certification, occurring on February 7, 2025. There's a history of violations, but they go back a ways. The last one was in 2018. So I would impose a $100 fine as to each of these violations and give them 30 days to pay.
Yes, based on material testimony provided today, I also agree with the chair's findings. A violation of Rule 4.20B, prohibited activities by license type, a fine of $100, and violation of Rule 3.052, alcohol wellness certificate, with a fine of $100.
Based on the violation report proffer made by counsel, and the admission made today, I also agree with the chairman and find that there was a violation of Rule 4.20B, prohibited activities by a license type, and a violation of Rule 3.052, alcohol awareness. On February 7th, 2025, also issue a $100 fine for each of those and give 30 days to pay.
Ms. Russell?
Exhibits for the record, Board Exhibit 1, violation report, Inspector Bass, 2 through 10, photos.
Thank you all, and good luck, sir.
Ram B. KC and Siraj K. Puri, new MSB Group LLC, trading as Blue Bay Bar and Liquor, 3724 Eastern Avenue, Class BD7 beer, wine, and liquor license. Violation of Rule 4.152, sexual practices and obscenity, on February 22nd, 2025, engaging in unlicensed adult entertainment. Violation of Rule 3.081B, sanitation and safety, on February 22nd, 2025, lit charcoal hookah inside the establishment in violation of the Clean Indoor Air Act. Violation of Rule 3.011, ownership and operation, on February 22, 2025, failure to disclose financial interest of Mohan Thapa and Jose Flores. Violation of Rule 4.181, alterations, February 22nd, 2025, storing alcohol in an unlicensed part of the establishment without approval. Please come forward.
For the record, Melvin J. Konetsky representing the licensee.
Good morning. Is this going to be admission or denial?
We'll make it an admission with an explanation.
Go ahead.
Well, in this particular location, they have an area that does a lot of packaged goods and having a bar area. And in the past, what has been happening, they were having a tough time getting participants in the bar area. So the area is basically a Latino area at this point. So they had acquired the services of Mr. Flores and his wife here to help run the portion of the place that's let's call it the tavern, from want of a better word. And when they were in there, that's the situation with the young lady, dancing in bra and panties and so forth, and a dance pole. Since then, they've removed the dance pole, removed any hookah that would have been there. No hookah. I mean, now I keep saying that. Maybe I'll start my conversation with no hookah, and take down the dance pole. And the actual ownership of the place is Mr. Siraj is here. Ram KC owns the building, and he's in Nepal. Mr. Thapa does not have any ownership interest. In fact, he's been in Nepal for the last year, and my understanding that he's presently in President's ice hazing for some reason on there. So as far as the situation regarding with the fire department, I see Lieutenant over there. He came in and Captain, I'm sorry. And they were closed for probably 35 or 40 days, correcting all the issues that the fire department wanted, and they have since been reopened. It cost them about $35,000, at least in income and the rent for being closed, but they're now open and operational. They moved the storage of the alcohol from the basement, so I think they're trying to get fully compliant on this situation. They haven't been before the board before, and it was transferred to them in 2023.
So who is operating and managing the facility?
Mr. Siraj is there every day, and then the manager here is working on the
Manager's name?
Carmen Rodriguez.
and Jose Flores is her husband up till now.
So one of the licensees, the manager, and her husband.
Yeah.
Okay. Can we swear the folks over here, please?
You swear affirm and penalty of perjury that the answers that you give in the statements that you make will be truthful and
I do.
If you could state your name, when, and if you do testify.
Agent Perez, you want to start?
Yes.
I just wanted to know if you're in sync with what I'm hearing, that things are getting improved and taken care of, or what do you know?
Agent Perez, Baltimore City Liquor Board. I've only been to the establishment once after this violation. It was during the day, during their slow time. There were only one employee there. At the time, no customers.
But everything was okay?
I didn't see any issues during that visit.
Can I ask the fire department personnel, captain and others, are you satisfied with what they've done?
Right now, sir, they're on an ongoing progress with Inspector Heinlein to the left of me. However, that night when we made entry into the location, there were significant inimical life safety issues that could have cost persons their lives. They were not just only operating as out of their permit with strip club. They had residential occupancy, non-compliant, no life safety system, zero emergency lighting, improper egress. They were closed down on 2/21. Ms. Cameron Rodriguez was designated as the owner's rep. Myself and Inspector Heinlein made a reinspection on 2/27. There was, we'll say, some notifications made through the fire department where I had to write up a complete report to the fire marshal because there was allegations that the fire department targeted them. This was brought up on a social club task force. So a complete report was subjugated to them. They had work in there without permits. They had no operational emergency lighting. They were cutting up the facility. They were storing a gas-powered motor scooter in there. So they remained closed until we felt satisfied, and they were required to get operational permits and construction permits. Inspector Heinlein went back after there in approximately around 3:24 after that to open it up, and we will be following up more with them.
As of that date, they were in compliance?
Yes,
State your name, please, sir.
Inspector Heinlein, FPB 37, Baltimore City Fire Marshal's Office.
I'm sorry, Captain Dennis Dawson, FPB 23.
Yeah, don't get us mixed up. Yeah, so this location has had a long history of violations. Different owners, but they've been written up many, many times. with
These
regard-
owners have only had it since 2023, though.
Yes, I'm just stating the history of the establishment. So on the day of the inspection, they did have a lot of life safety issues. The rear of the club, they have trash that's piled up with rodents all over the place. That was taken care of that day. The other issue was that they built the stage in the back, and they literally covered the electrical panel. So there was no access to the electrical panel. So they were cooperative, and they moved the boards that they had covering the electric panels, which is a huge life safety issue. They had a storage in the basement that nobody knew about, where they stored alcohol, and then they have people living on the second floor. Since the inspection, since the re-inspection, they are compliant now. They were very cooperative, and we look forward to working with them going forward with compliance. But as of now, they're compliant.
Allow them to reopen?
What was that date, Cap?
It was after 324.
After 3/24.
So they were closed from 2/22 to 3/24.
21 through.
Yeah, okay, fine, that's what I,
Did you have any questions?
no, I think they accurately, once they found out what the situation was, they paid a financial penalty for doing things that they should have known better. They haven't been before the board before, and I don't hope we never see them again.
As do we. Commissioners have any questions?
No question.
I have no questions. All right. Thank you. On the basis of the materials contained in the charging documents, the proffer from counsel, including the admission of the violations and the testimony received, I find violations of Rule 4.152, sexual practices and obscenity, violation of Rule 3.081B, sanitation and safety, violation of Rule 3.011, ownership and operation, and violation of Rule 4.18.1, alterations, all occurring on February 22, 2025. As to each of these violations, I would impose a $300 fine, and I would give them 30 days to pay.
Yes, based on materials, testimony provided today, I also agree with the chair's findings. A violation of Rule 4.152, sexual practice and obscenity, with a fine of $300. Violation of Rule 3.081B, sanitation and safety, with a fine of $300. Violation of Rule 3.01, ownership and operation, with a fine of $300. Violation of Rule 4.181, alterations, with a fine of $300.
Based on the violation report, proffer made by counsel, admission made today, testimony given, any evidence that's been admitted. I also find a violation of Rule 4.52, sexual practices and obscenity, violation of Rule 3.081B, sanitation and safety, a violation of Rule 3.01, ownership and operation, a violation of Rule 4.181, alterations. Also agree with the $300 fine for each of those, for all the violations that happened on February 22nd, 2025.
Ms. Russell?
For the record, for Exhibit 1, violation report Inspector Bass. 2, violation report Agent Perez. 3 through 11 photos.
Thank you. Good luck.
Thank you.
Bijou, Penland, and Blanca Pesquera, New Ecstasy Bar and Restaurant LLC, trading as My Cousin's Place, 3925 through 27 East Lombard Street, Class BD7, beer, wine, and liquor license. Excuse me, violation of Rule 4.081, relations with wholesalers, on February 7, 2025, purchasing alcohol from an establishment that is not a licensed manufacturer or wholesaler, violation of Rule 3.081D, sanitation and safety on February 7th, 2025, failure to have sufficient emergency lighting, and violation of Rule 3.092, restroom facilities and health regulations on February 7th, 2025, failure to maintain the establishment in sanitary condition and having a non-suctioning hood. Please come forward.
For the record, Melvin Jaconeski, representing the licensee.
Good morning again, Mr. Cadency. Admissions or denial?
We'll make an admission with an explanation on it.
Please proceed.
And in this particular establishment, the persons have been there, they've been having a really tough time. I don't know if you remember this location. You might have remembered it years ago as My Cousin's Place, right up from Buddy Polino's. They had 2 fires, within a period of 3 or 4 months. They hired contractors to come in And when they went ahead and did all the work, lo and behold, you would find this hard to believe, they didn't follow the plans. They didn't do the right fire separations and so forth. Although they took their money, rule number one, as a result of which they had problems, and the fire department is their captain, is here, and then they were trying to correct this situation. They were just trying to get reopened, and they were running short on trying to get things. So they went and they bought from a retailer. They understand, they admit that they cannot do that. They know they had to clean everything up. The problem was they were having with their cooking equipment, the suctioning equipment for the hood system is not operating, and they're working to get that done. They're trying to get everything else done. They were closed 2 months, 2 whole months they were closed. They met with Captain Dawson, and they were given the provisionals to reopen and not use the kitchen until they got the situation taken care of with the hood system and a couple other issues. And they're also pursuing the contractor in this case. I'm not doing, somebody else is, for the work that they were supposed to do. They didn't. And in the meantime, to add to it, there's a change in ownership in the building. So it is a situation that's in a case of flux.
Just out of curiosity, so it's less expensive to purchase from a retailer than a wholesaler?
As I understand it now, just from my limited experience over 55 years, what they're doing is they're paying double sales tax. So they're paying 9% when they buy it from a retailer, and then when they sell it, they also have to pay another 9%. But what happens a lot of times, the places running, we call them get a case of the shorts. So when they're short, maybe they have big Coors Light people, and then they go buy and they come there. If you look at the pictures, it wasn't a lot, but they went and bought it because they had customers and they were trying to get it open and operating. It became an issue years ago because what happened is they can't track purchases and sales, and the controller was very adamant about making sure that doesn't happen.
Can we swear? Who's going to speak for us? Go ahead, please identify yourself.
Inspector Jordan, good morning. Pertaining to the issues on the violation, I believe they are in compliance and they were reopened. And they were cooperative.
Fire department have anything to add to this?
They're still in transition. Effective on February 21st, they were immediately given a cease and desist order. It's not on the tenant for the first floor that's operating a bar. It's more on the landlord, which is listed as a Lombard Realty. At this time, they have a formal notice from the Office of the Fire Marshal. They have a contingent opening. They just put in the ownership, not from the bar, put in a request for us to review what they plan to do. If they do not, we will issue a closure order on the structure. So if this is not resolved in 30 days.
Primarily with the owner of the building, not with the licensee?
Yeah, unfortunately, the licensee just got caught in the middle because they're in an occupancy, and the building plans that were submitted was to separate the building in fire areas, so they didn't have to sprinkler the whole building. Problem is, it got found out that they didn't separate the building. The sprinkler system in there gives the impression of a life safety. It's not going to work if there's a significant fire on the first floor. And the only thing they've really had going on was really maintaining the hood suppression system. They're kind of stuck in the middle, but the fire alarm, the sprinklers, the emergency lighting, the fire separation is solely on the property owners.
Okay. Commissioners have any questions?
So do they have their occupancy permit?
They were given an occupancy permit. The occupancy permit doesn't include as far as the building construction, so in accordance with the building fire-related codes of Baltimore City, both the building, IBC, and IFC Chapter 1, they didn't go with their construction plans. That was not caught because technically the fire separation is supposed to be done by a third-party reviewer. It was not, okay? So it was not caught. The building inspectors issued a certificate of occupancy for the second floor being a tenement, short-term stay, and the first floor being an assembly. However, under those codes, both the building and the fire department can revoke that certificate of occupancy. And we found that they were not compliant with their stamped construction plans. They don't comply within 30 days, we will go for that.
Good. Okay. Anything further, Mr.?
Nothing further.
All right. On the basis of the materials contained in the charging documents, the proffer from counsel, which includes an admission of the violations and the testimony received, I find a violation of Rule 4.081, relations with wholesalers, a violation of Rule 3.081D, sanitation and safety, and a violation of Rule 3.092, restroom facilities and health regulations occurring on February 7, 2025. I note that they appeared before us on February 27th for a bunch of violations, and these had been noted before that time. So they've got a lot of problems at this place, and there's a long history of violations before the board. So I don't know if it can be cleaned up or if they're going to have to vacate that facility if the owner isn't going to be in compliance. In any event, I'd impose fines of $500 as to each of these violations and give them 30 days to pay.
Yes, based on material testimony provided today, I agree with the chair's findings of violation of Rule 4.081, relations with wholesalers with a fine of $500, violation of Rule 3.081D, sanitation and safety with a fine of $500, and violation of Rule 3.092, restroom facilities and health regulations with a fine of $500.
Based on the violation report proper made by counsel, with the admission, the testimony given also today, also agree with the chairman and find a violation of Rule 4.081, relations with wholesalers, violation of Rule 3.081D, sanitation and safety, violation of Rule 3.092, restroom facilities and health regulations, all on February 7th, 2025. Issue of $500 for each with 30 days to pay.
Ms. Russell?
This for the record, Board Exhibit 1, violation report, Inspector Jordan, 2 through 7 photos.
Thank you.
Good luck.
Thomas Bennett Jr. and Reggie Ware III, Bar Elite LLC, trading as Bar Elite, 1571 Ridgely Street, Class D, beer, wine, and liquor license. Violation of Rule 4.181, alterations on March 1st, 2025, allowing patrons on the second floor without approval from the board, and violation of Rule 4.14, live entertainment without authorization on March 1st, 2025. Please come forward.
For the record, Melvin Jaconesky, representing the licensees, that there would be an admission with an explanation on this situation.
Okay.
This is a small place. It's hello. It has a D license, so they struggle to try to compete with the big boys in the area. It's close to the state, and we've been in the process of trying to get a authorization, excuse me, for live entertainment. We're in the process of getting site plans to submit to zoning. And once again, it's a nightmare to try to get through their portals, but we're working on it. And so the upstairs, their explanation, they mainly had people up there they weren't supposed to be there, and they were mainly family members. They know they can't have anybody upstairs, and they haven't been before the board before, and I don't think you're going to see them there again.
Okay. You've already been sworn, is that
Yes,
correct?
sir.
Yeah. Are they compliant?
I have not been back to the establishment since. Does anyone else know if they've been compliant?
Were they cooperative when you were there?
Yes, they were.
Okay. Commissioners have any questions?
No question.
All right, thank you. On the basis of the materials contained in the charging documents, the proffer from counsel, including the admissions of the violations and any testimony received, I find a violation of Rule 4.181, alterations, a violation of Rule 4.14, live entertainment without authorization on March 1, 2025. I'd impose a $150 fine as to each and give them 30 days to pay.
Yes, based on materials and testimony provided today, I also agree with the chair's findings, a violation of Rule 4.181, alterations with a fine of $150, violation of Rule 4.14, live entertainment without authorization with a fine of $150.
Based on the violation report properly made by counsel and testimony given today, I also find a violation of Rule 4.181, alterations, and a violation of Rule 4.14, live entertainment without authorization on March 1st, 2025. I also agree with the $150 fine for each. 30 days.
All right, thank you very much.
Exhibits for the record, Board Exhibit 1, violation report, Inspector Bass, 2 through 4 photos.
Okay, thank you. Good luck, gentlemen.
Sorry I stepped on your lines, Ms. Russell.
Don't let it happen again. All right. Case number 14, Gerardo Garcia Sanchez, Garcia Restaurant LLC, trading as Carnitas Rosia, 500 South Wolf Street, Class B, beer, wine, and liquor license. Violation of Rule 4.181, alterations on January 24, 2025. Establishing a bar on the second floor without approval from the board. Violation of Rule 4.182, alterations, operating a kitchen on the second floor without a health department permit. And violation of Rule 3.081D, sanitation and safety on January 24, 2025. A blocked emergency exit. Please come forward.
All right, good morning, Your Honor. Good morning, Commissioner Stephen W. Fogelman on behalf of the licensee. Mr. Sanchez, Garcia Sanchez is to my right.
Good morning. Will this be an admission or denial?
With respect to, yes, this will be admissions to the three rule violations.
Okay. You want to proffer?
Yes, I do. Your Honor, this one is, it's a little bit confusing to me, and I speak English as a first language. I wasn't going to make my joke about how crowded it was earlier, but luckily we have several fire marshals in here. So in any event, it's really confusing. I filed a transfer for this gentleman back in 2018. At that time, they were using the first and second floor as a bar. I copied the language off the certificate of occupancy from the prior use as restaurant. The UNO continues to say to this day, continue to use as restaurant with bar. And when you don't delineate first and second floor, that usually means use the premises as a restaurant and bar. And that's how the Liquor Board approved it. That's how Housing approved it. Mr. Garcia Sanchez and, quite frankly, too many people are unaware of this rule. You know, ignorance of the law is no excuse. We understand that. He didn't write to the Liquor Board and say, and I just wish people would call me. I wish they would call the agency and just say, hey, I'm going to build a little bar up here. Didn't do that. Built his little bar on the second floor. And this is where it gets even more confusing if you're the licensee. The fire prevention annual permit all the way up until 2023 says continue use as a restaurant. Use of the premises as a restaurant, first and second floor, no live entertainment, capacity 150 persons. All of a sudden, in about 23, 24, now it just says continue to use as a restaurant and bar. It doesn't specifically include or exclude the second floor. So my clients always believe that he has the right under the liquor license, under the fire permit, and under the use and occupancy permit to indeed use the second floor for licensed business and being part of the licensed premises. That said, there's absolutely, no excuse for not letting the Liquor Board know whenever you're doing alterations. And he completely understands that. If you're going to even change a small configuration of your bar, you've got to let the Liquor Board know. With respect to the sanitation and safety, Mr. Garcia Sanchez completely understands that he will make sure to ensure safety in the future. Yeah, and that can't happen. And so that has been ameliorated, and that will not happen again. So I see this more as a misunderstanding. This is not like his last charge with live entertainment without authorization. This is paperwork that he's got on his wall that he's relying on. But again, you've got to let the Liquor Board know when you're changing the configuration of your bar, and that's undisputed.
You gentlemen are under oath. You want to add anything, Agent?
Captain Dawson can elaborate more as far as the use of the second floor. I wasn't aware of it, just like the licensee wasn't aware of it. I've been inspecting the location for several years, and I was under the impression that the second floor was included as well until this date.
Captain, did you want to add anything?
Captain Dennis Dawson, FPB 23. This location here, unfortunately, is a cut-up and mixed building that goes down several, so it's a mixed-use occupancy. The fire prevention permits usually delineate or try to delineate specifications within the building. Unfortunately, we have persons, when they apply for use and occupancy, they just say, I'm using it as a bar and restaurant. They should include all areas of the building on their permit. This location here, I have personal knowledge of it from several years, because I'm on a design and engineering review. And the night that I went there in question, this building did not have sprinklers. I already knew that their hood suppression system wasn't installed properly and that it was venting up through the second and third floor and did not have fire wrapping. And we did use the language line because there was a language barrier to give them Spanish. I walked through with them that night, communicated. Myself and Inspector Heinlein also met with ownership shortly thereafter, reduced their occupancy, reduced them down to only using the first floor.
Okay.
And then they had a representative that they are supposed to follow up with us when they get a design consultant to be able to use. Anything above that first floor or above 100 persons will require a full fire sprinkler system in that building. There's areas that you won't know because there was rearrangements of doors that were covered up. Due to my prior knowledge, I remembered what was where. So we had doors that were moved, doors that were covered up to kind of give you a falseness. I can't say who did it, but it was violation of fire code. They've been compliant as far as we are aware of. We went by there several times on task force, haven't found any issues because there was neighborhood complaints. But there are additional permits you may not see that we see because of block and lot. But they need to follow up with myself or Inspector Heinlein to get this building. Right now, they are down below 100 for their occupant load. Okay. And they're restricted to that first floor and the table set up that they have.
Did you want to add something?
I do. I would like to correct Mr. Goldman. It's not a little small bar on the second floor. It's a very large area.
But that's closed for now.
Yes.
Right. Okay. How long were they closed? That was the question.
That I'm not aware.
Do you know?
It was only closed for a couple of weeks, and then we went back and reopened them when they did the egress signs, the exit signs, emergency lighting, and discontinued the use of extension cords.
I have one. I just have one quick question. I mean, this is a great learning experience, and to have two great captains here for our city.
I'm just an inspector.
I want to make sure I understand so they can do it right because they will ask me. So they're gonna attempt to pull a new permit to specifically include the first and second floor, a new UNO, and then you're going to need design, a full design.
So in response, the gentleman sitting here was their consultant and representative met with us. Okay, you need to determine what you want to use of the building and where. The only way you're going to that second floor is if you're putting sprinklers in that building.
Okay.
Okay, and there were walls that rebuilt to separate the kitchen. There was no building permits on it. There was doors covered up. So they were directed, get a consult, get an architectural design, figure it out, and we will walk you from there. But right now, there's not going to be any further discussion until we get plans and they figure out they're just going to be held as where they are with the reduced occupancy, right to the first floor.
And assuming they go through that, then I guess all I'm wondering is, do they need a new use and occupancy to specifically include first and
Yes,
second
sir.
floor?
Once we turn around, they go through design review, we will walk them through to put the exact wording,
Mhm.
and it will also give a capacity on the use and occupancy, so we don't have these issues.
And then finally, not really a question directed to you, though, then I imagine, even though we were approved to use the entire premises as a bar 7 years ago, that the liquor board may require us to come back in for an expansion to specifically include the second floor. And that's, I appreciate your head nod.
Mr. Fogelman, so we will definitely require that. Also, something to consider, I believe this is still in the 46th district?
Yes.
And so, since it is a B, there is still seating requirements.
Right.
That we need to double check and make
Mhm.
sure they're going to be able to comply with that.
With the 75 seats. Right. Okay, thank you very much. And based on all that, I would ask that you consider a slight reduction of the fine because this is all going to be very expensive for these owners to come into this full compliance to use the entire premises as a restaurant and bar.
They
Thank
were
you.
Just here.
Yes.
In February with another series of violations. So they may need more than a pat on the back.
Absolutely. No, and they understand that. I would say that the charges that in lieu of we had a little hearing in lieu of the payable fine, those were different charges. These are very technical.
They're different.
But they're also based on safety. And I think finally the minds are understanding all the work that does need to be done. So I thank you for that.
Anything further, Commissioner? No. All right, thank you. On the basis of the materials contained in the charging documents, the proffer from counsel, which included admission of the violations and the testimony received, I find a violation of Rule 4.181 alterations a violation of Rule 4.182 alterations, a violation of Rule 3.081D sanitation and safety, all occurring on January 24, 2025, and I impose a $300 fine as to each and give them 30 days to pay.
Yes, based on materials and testimony provided today, I also agree with the chair's findings, a violation of Rule 4.181, alterations of $300, violation of Rule 4.182, alterations, fine of $300, and violation of Rule 3.081D, sanitation and safety, $300.
Based on the violation report proffered made by counsel with the admission testimony given today, I also find a violation of Rule 4.181 alterations and a violation of Rule 4.182 alterations and a violation of Rule 3.081D sanitation and safety on January 24th, 2025. I agree with the $300 fine for each of those violations with 30 days of pay.
Ms. Russell?
Request for the record, Board Exhibit 1, violation report, Agent Perez.
Thank you. Good luck.
Thank you all.
Thank you, folks.
Aisha Ali and Myrtle Johnson, Despot LLC, trading as Despot, 1171 through 73 West Hamburg Street, Class BD7 beer, wine, and liquor license. Violation of Rule 4.181, alterations on March 7, 2025, patron consuming Modelo beer on the unlicensed outdoor deck. Violation of Rule 3.081B, sanitation and safety on March 15, 2025, individuals smoking hookah inside the establishment in violation of the Clean Indoor Air Act. Violation of Rule 3.12, general welfare on March 31st, 2025, overcrowding. Violation of Rule 3.081B, sanitation and safety on March 31st, 2025, individuals smoking hookah inside the establishment in violation of the Clean Indoor Air Act. And then finally, violation of Rule 4.071, open containers and illegal possession and consumption of alcoholic beverages on March 31st, 2025. Patrons leaving the establishment with alcoholic beverages, please come forward.
Good morning, Stephen W. Fogon on behalf of the licensee Aisha Ali, who's here to my right.
Do you want to admit or deny?
Well, this will be it's a mix and match. We'll go ahead and we'll admit to the alterations of March 7, 4.181. We will admit to 3081B for March 15th. We will deny as to the 3.12 on March 31st. We will admit to the 3.081B for March 31st. And we will deny as to the 4.071 on March 31st. We don't expect this to be a long contested hearing. I'll explain, why.
Nor do I. Inspector Jordan or Agent Tudhope, who's going to testify?
March 31st.
March 31st, just as to these issues, the the general welfare violation and the open container violation.
Good morning, Inspector Jordan. On March 31st, at approximately 7 p.m., we responded to the location with reports of overcrowding. We waited for members of the fire marshal's office to arrive to assist us to assess the safety and any issues at the location pertaining to safety specifically. While we were waiting, we observed numerous people coming in and out with alcohol in their hands. Specifically, I saw Tito's bottle, liquor bottle. Also, we didn't see that they had anything in place to keep account, like no system in place. People were just coming in and out of the two front doors. Once the fire marshal's office arrived, they assessed the situation and they closed them due to overcrowding and also hookah. They were smoking hookah. Once we went inside, it was very smoky. Obviously, there was numerous people smoking hookah.
You have questions?
I do, thank you. Inspector Jordan, you said you were waiting for Fire Marshal to show up, right?
Yes, there was 2 members that arrived there.
And who were they?
They were Dell Holmes and Jeffrey Holman.
All right, so not the gentlemen who are here today. Okay. Would it surprise you if those individuals told my licensee and the manager that they were shutting the bar down, but not for overcrowding, but for hookah? And that in their opinion, that they had not exceeded their capacity.
Well, I believe because by the time we went in, people had already started leaving. Like they were compliant in letting people leave because of the crowded conditions.
Right, and you're aware that that was opening day for the Baltimore Orioles home game.
I don't watch football.
All right.
Orioles don't play football.
No further questions.
They don't play much baseball these days.
So you understand that there were people who had probably been drinking since 10 a.m., gone to the game, continued to drink, and then came into the bar, near their parking spot, and were in there and racing out when they see the liquor board coming in, right?
I am not
Let me ask
sure
you
what they were thinking.
Inspector, did the fire department personnel tell you that they found it overcrowded?
It was for safety concerns, citing safety concerns. They closed it down, and also for the fire hazard posed by the hookah and the charcoal hookah.
Do you understand what the safety concerns meant?
I'm not sure if that included the overcrowded, but definitely for the hookah.
I mean, remembering this is the fire department we're talking about, a burning hydrocarbon with charcoal.
So let's go on to the
Sure.
open container.
Okay. And we're still on March 31st. That's what you're involved with, right, Inspector?
Yes.
And only that, right?
Yes.
Okay. With respect to the sanitation and safety,
You admitted that.
we have admitted that. I'll be happy to explain in mitigation.
In a minute.
Yeah.
But let's go to the open container that you denied.
Right. It's as simple as this, as far as a proffer, is that my client, the manager, did not see people running out of there when the liquor board came, but the liquor board may have seen it. They never saw that or had any personal knowledge of that.
Did you see that?
I did. I actually have a picture of a young lady. It's hard to capture pictures. You don't want to make people angry, especially if they've been drinking. But there is a picture of a young lady walking out with a Tito's bottle.
It is exhibit number 5 in your binders.
And Inspector, you're not sure where that came from? You're not sure if that came out of her purse?
Well,
whether it was purchased on site?
Once inside, when when fire department was speaking to the licensee, we were speaking in a stock room, and there was like a large amount of Tito's bottles back there. So, and I definitely saw her, she was coming from that direction, from inside.
But you never saw anybody purchase a bottle of Tito's over the counter of the bar, did you?
I didn't see the purchase, no.
Okay, yeah. All right, as far as March 31st, I have no questions, Your Honor.
You want to
Commissioners?
tell us about the admissions?
Yes, and this will bleed into the next 2 dates, which I assume we're going to do reverse chronologically.
You can go however you want.
We got hits on 2 of those. And in the words of the legendary Melvin Kadinsky, no hookah, no hookah, no hookah, okay? To my client's credit or detriment, the manager of this establishment has been to clubs, some of which I wonder if they even have licenses, downtown, some after hours, some not, where people are smoking hookahs, and in some places, people are purchasing alcohol, all right? They are not under the jurisdiction of the Board of Liquor License Commissioners. Quite frankly, they're under the jurisdiction of the BPD. Somehow, they persevere. That said, the manager has been asked about hookah for months and months. He's been to these clubs where the hookahs are out and omnipresent. But under no circumstances can you have anything burning indoor. It's the Maryland Clean Indoor Air Act of 2008. That said, Ms. Ali contacted by phone health department, fire department, several agencies, and basically could not get a straight answer on whether or not that was allowed. I wish she had called me.
She was in front of the board in April for violations of sanitation and safety. 2 violations. Wasn't that the same thing?
Well, she was in front of the board in April. You're talking this April?
Yes, April 23rd.
Right, well,
And
right.
When were those violations?
January. I don't know when the April violations
She was
were.
violated. I'm just wondering.
Yeah, I
if
don't
she was
have that
previously
information.
violated for the same thing.
Right. Well,
Didn't she learn that we found that was a violation?
she certainly, it is crystal clear as of today. And as far as I know, there were no hookahs after January 31st, but I was not involved in that matter. And the materials provided by the board show a 423 appearance, but don't go any further as far as when those violations may have
I'm
occurred.
just saying, by March 7th, she should have known.
Well, again, I'll assume with you that those charges were prior. I don't, and I was probably at that hearing, but not on their behalf. I just have no memory of that. That said,
As with the vodka, circumstantial evidence.
well, no, I mean, I think it's pretty clear. There's no circumstantial evidence. There is no arguing whether or not burning hydrocarbons. Oh, right, right. Well, I don't know. We don't know. What we do know, on staying on March 31st, is that they had never been slammed before, is a word. They had never really had much of a crowd for opening day. Ravens game days, definitely. And in fact, on Ravens game days, they hire security. They didn't see a crowd coming on opening day for baseball, and they did not hire a security guard to answer why there was no one at the front door to make sure that patrons would not escape with alcoholic beverages. So that's also been a learning experience that they're going to take with them, that on opening day of any kind, they're going to make sure to have security. They will not have hookah inside or cigarettes inside at all going forward. And I think that should address the March 31st incident.
Mr. Chair, can I just say one thing, just so that your client is aware? The Clean Indoor Act was amended, and so there's no smoking hookah of any kind, no vaping inside. Just so it's not just charcoal, it's the other kind as well. Just wanted
Yes,
to be clear.
cigars, tobacco, all of it, yeah. And I made that clear to her.
Did you have anything else?
Yes, with respect to March, let's start with March 7th, if you don't mind. I had prepared this chronologically. And let me go ahead and save everyone's time and tell you that with respect to March 7th, we do not deny that perhaps there was somebody on the deck having a drink, but we never, my client never saw this person. They were told by the liquor board there was a guy out back on the deck holding a beer, and by the time they got out there to the deck, there was no one there. So that's the denial in that regard, or not admitting full responsibility. But the crux of that issue is that, like in the last case, they made alterations without notifying the liquor board. That said, Ms. Ali hired a contractor, pulled a permit, relied on that contractor to finish the deck and get final approval for the use and occupancy. For whatever reason, that did not occur. It was not, I mean, I have seen cases where somebody just builds a deck, all by themselves. In this case, she attempted to comply. She was not aware that she needed to let the liquor board know. And as I said in the last case, it's just pick up the phone and call me, call the agency. Sometimes it's as simple as an email and a pencil drawing showing what you're going to do, inviting an inspector to come out and look at it. And the liquor board is usually pretty permissive about approval of certain alterations. But with notice. Notice is key. So once again, she will make sure that there is full notice given if there's any if there's any proposed alterations at the licensed premises. So that's all I have to say about March 7th. And
Anything else on March 15th?
March 15th.
That's the hookah, right?
Yes, that's a hookah, so I won't belabor that any longer. The overcrowding, like I say, I'm relying on what she is saying, and her manager who's here was told that, and perhaps, as the inspector said, that perhaps because there were less people by the time the fire marshal showed up, that he only closed them down for that. I don't know. Nobody has given me a number as to how many people they tried to count. And with respect to the leaving the establishment of alcoholic beverages, the manager and the licensee just simply didn't see that. We're not questioning the veracity of the inspectors who are especially at the front door and who would be in a better position to see that.
You have something to add?
I do have something to add. I have spoken to Mr. Dontre Cotton, the manager, excessive of 3 times since the last violation about not having charcoal hookah inside. He just kind of dismisses me every time, and every time I go there, they're smoking charcoal hookah.
Wait, I'm going to object. I mean, first of all, we are looking at a snapshot of what happened on March 7th, 15th, and 31st. And then subsequent conversation. I don't know if she's talking about subsequent.
Those violations anyway, so
On all those occasions, I have spoken to Mr. Dontre Cotton about not having charcoal hookah.
I think counsel has made it clear to his client today that going forward, they can't do that.
And I'll bring Mr. Cotton up, and I don't think he'll be dismissive about it. I think there is no question in his mind that stops.
And just an FYI, Mr. Chair, there was some conversation about the monetary penalty admission that was from December 22nd, 2024, and that was for smoking hookah. So just an FYI.
Okay. Anything further?
No more. No hookahs.
Okay. Thank you, everybody. On the basis then of the materials contained in the charging documents, the proffer from counsel, which include certain admissions, which we will go through, and the testimony received, I find a violation of Rule 4.181 alterations on March 7, 2025. Find a violation of Rule 3.081B sanitation and safety on March 15, 2025. As to the violation of Rule 3.12 general welfare on March 31, I would dismiss that violation for lack of proof. As to, I find a violation of Rule 3.081B sanitation and safety and a violation of Rule 4.071 open containers on March 31, 2025. As to the violation of March 7, I impose a $300 fine. As to the violation of March 15, I impose a $300 fine. As to the violations on March 31, the 2 of them, I impose $300 fines as to each, and I give 30 days to pay.
Yes. Mr. Chair, for clarification, violation, the last one, violation of Rule 4.071, open containers in illegal possession. You label that as a fine.
I found a violation and imposed a $300 fine.
Okay. Based on material and testimony provided today, I agree with the chair's findings. A violation of Rule 4.181 alterations with a fine of $300. Violation of Rule 3.081B sanitation and safety, fine of $300. Violation of Rule 3.12 general welfare was dismissed. Violation of Rule 3.081B sanitation and safety with a fine of $300. And violation of Rule 4.071 open containers and illegal possession and consumption of alcoholic beverages with a fine of $300.
Based on the violation report properly made by counsel, testimony given today, I also find a violation of Rule 4.181 alterations on March 7th, 2025. I also find a violation of Rule 3.081B sanitation and safety on March 15th, 2025. Also, will dismiss violation 3.12 general welfare, which happened on March 31st of 2025. I do find a violation of Rule 3.081B sanitation and safety and a violation of Rule 4.071 1, open containers and illegal possession of and consumption of alcoholic beverages on March 31st, 2025. Issue a $300 fine for each of those violations, 30 days of pay. Ms. Russell.
Close service for the record. Exhibit 1, violation report, Agent Perez. 2, violation report, Agent Tudhope, and 3 through 10 photos.
Thank you all. That includes the inspectors as agents, as always. Thank you.
Juliana McGuire, Sangria LLC, trading as Sangria, 930 North Charles Street, Class B, beer, wine, and liquor license. Violation of Rule 4.202, specific requirements of prohibited activities by license type, failure to maintain an operating kitchen and lack of food to be prepared and served. Violation of Rule 3.034, records on, but the other one was on March 28th as well, 2025, failure to provide a valid trader's license when requested by the Liquor Board, and violation of Rule 3.081B, sanitation and safety, on March 28th, failure to maintain a valid health permit and lack of hot water. Please come forward. You are not the licensee, is that
No,
correct?
I think I need to be on this side. I'm from the
Yeah, is the
community.
licensee here or any attorneys representing?
Do we have service on them?
So, Mr. Chairman, we were not able to serve at the location, but we do have proof that the licensee received a mailing at their home.
Can we make that part of the record?
Yes, sir.
Okay. Well, we're going to go forward then. So please tell us what you found on March 28th, 2025.
Agent Toto, Baltimore City Liquor Board. On March 28, 2025, at approximately 9 p.m., the Social Club Task Force, consisting of the Baltimore City Liquor Board, Agent Perez, Inspector Jordan, and myself, Baltimore City Health Department, and Baltimore Housing Special Investigation Unit, conducted a joint inspection at Sangria, located at 930 North Charles. Once we went inside the establishment, we made contact with the owner, Mr. Rex Allen Murray, Jr., as identified by his Maryland driver's license. Agent Perez instructed Mr. Murray to provide all licensing and permits pertaining to the business. Mr. Murray could only provide low-quality printed-out pictures of the liquor license and a printed-out picture of an expired health permit and no trader's license. Agent Perez then asked Mr. Murray if he could provide originals, and he said he did not. They were unreadable and unacceptable. Mr. Murray stated that he did not have the originals available to him. I then proceeded to do a full inspection of the establishment. Upon inspection of the kitchen, it was found to be non-operational. No food items were observed inside the fridges or anywhere within the establishment. The kitchen appliances were unplugged and not in use. Several floor tiles were broken or missing. The washing area sink pipes were duct taped together, and it appeared that the main kitchen floor had recently been painted. It must be noted that this establishment has a 50% minimum daily food receipts as a restriction to their liquor license as part of a MOU dated 1/18/2017. I, Agent Tudhope, informed Mr. Murray that he would be receiving violations from the Liquor Board. Mr. Murray then was informed by the Health Department that the establishment would be closed for them operating without a valid health permit and not having hot water. The establishment was posted with a closure sign, and the task force left without further incidents.
Do you have anything to add, Agent?
I don't.
Okay. Sir, who are you?
Yes. Good morning, Commissioners. For the record, Jack Dana, President of the Mount Vernon Belvedere Association.
Raise your right hand, please, so we can hear you.
Sure. I do. Sure. Jack? Sure. Yep. Dana, D-A-N-N-A. Just briefly, we submitted a letter on Tuesday. Thank you, Stacy. An hour late. You always kind of help me out. But I just wanted to come this afternoon or this morning to put on the record, these violations are nothing new. It was illustrated in a very robust discussion when we were protesting the renewal in 2023. Since then, there's not been an operational kitchen, nor has there been a menu on the website. There have been additional health code violations, and the new operator, Mr. Nowako, whom we've met with in late November, We shared the history. We're optimistic for a new operator, for a new path forward. All of those issues were discussed with Mr. Nowako. He assured us that Sangria would come into compliance, and due to the inspection and the task force, those violations are still clear. So we urge the commissioners to find Sangria and the license and the operator in violation.
Thank you. Commissioners have any questions?
No question.
No question. Do we know whether the licensee paid the fines that were imposed back in February?
Yes, they paid the $425 March 28th.
All right, thank you. On the basis then of the materials contained in the charging documents and the testimony received, to find a violation of Rule 4.202, specific requirements and prohibited activities by license type, a violation of Rule 3.034, records, and a violation of Rule 3.081B, sanitation and safety, all occurring on March 28, 2025. I would suspend this license pending the licensee's ability to establish that they've complied with our requirements. Until they do that, the license is suspended as far as I'm concerned.
Thank you. Based on materials and testimony provided today, I agree with the chair's findings of violation of Rule 4.202, specific requirements, prohibited activities by license type, violation of Rule 3.034, records, violation of Rule 3.081B, sanitation and safety, with a suspended license.
Based on the application, the violation report, the proffer made, testimony given by agents here today, I also find that there was a violation of Rule 4.202, specific requirements and prohibited use by license type, violation of Rule 3.034, records, and a violation of Rule 3.081B, sanitation and safety, all on March 28, 2025. I also do agree with the chair, suspend this license until the licensee complies with all of our requirements. Once that's done,
Ms. Russell?
Mike Moses, for the record, Board Exhibit 1, violation report, Agent Tudhope, 2 through 11 photos, 12, letter from Mount Vernon Belvedere Association dated 5/2025, and 13, USPS certified mail proof.
Thank you all.
Thank you.
Final case for the day, Ariel Spirit, Maryland Yards LLC, trading as Maryland Yards, 511 West Pratt Street. Class B beer, wine, and liquor license, violation of Rule 3.12, general welfare, on March 31st, 2025, overcrowding. Violation of Rule 4.071, open containers and legal possession and consumption of alcoholic beverages on March 31st, 2025. Outdoor bar setup and failure to adhere to requirements that the alcohol must be served to patrons seated at tables. Please come forward.
For the record, Melvin J. Kudensky, representing the licensee. Be a general denial, just to get some information, and I think we'll be quick on this.
Okay. Raise your right hand, please.
I do. Agent Chase, Baltimore City Liquor Board.
Agent, can you tell us what happened on March 31?
Yes. On March 31st, 2025, at approximately 12:20 p.m., Inspector Brown and myself was working opening day while conducting our rounds at Maryland Yards. We found them open and operating with 2 outdoor bars and table service, with several patrons walking in and out of the establishment with drinks. We entered and met with the manager, Mr. Steffen. We asked to see his licenses and his one-day extension. He could not provide a one-day extension. The fire marshal was present, and he advised him that he was over capacity outside. The total capacity outside is 66 seated. We advised him to take the indoor bars, the bars inside, and to make sure that the patrons were seated while consuming alcohol.
Okay, do you have any questions?
Yeah, and this was opening day, is that correct?
Yes.
There was 45,000 people downtown.
Yes.
And there were Pickles and Section 771, they had all Washington Boulevard blocked off the whole street.
Yes, but those establishments had outdoor extensions for that day.
What kind of extension are you talking about?
It's a one-day extension that allows patrons to actually extend to the street side or as much as the fire marshals and zoning will allow them.
So you're talking about the temporary outdoor extension of licensed premises for $200, correct?
Yes.
He has outdoor permission on his license, is that correct?
Yes, he
So
does.
that wouldn't apply to him. It's only if you go into the street, is that correct?
Not just the street. So his outdoor table service is for seated patrons. It was a lot of patrons walking around. That's what the extension is for. They have to be
So
seated.
you're saying if they get that extension, they can put a bar and put music and everything out there. Is that what you're saying?
If that's what it allows.
And how do you know? I'm asking you what is allowed, because there seems to be some confusion on that.
Well, he didn't have an extension at all, and the people were supposed to be
If he
seated.
had outdoor table service with a licensed premises and they weren't in the public thoroughfare, why would he need to extend the license that he already has?
He needed that extension so that people could walk around because people were actually entering his bar to come around to the rest of the establishments as well.
And do you cite any other places that were there? Did you cite 771?
No, we did not cite 7071 because they had an outdoor extension.
And how about the Pickles?
Pickles also had an outdoor extension.
And did you ever go over in the parking lot over and cite anybody that was drinking in the parking lot over to Oriole Park?
They don't have a
They don't have a license.
Oriole Park does have a license.
Well, I don't know who runs the parking lot.
No, but I'm saying is one of my pet peeves is nobody cites people who do tailgating and either the Raven games and stuff. You're not allowed to drink outside. And you can tell me you go to a Raven game and they're not drinking outside, or you can cut my finger off, the little one only.
Mr. Kadetsky, just to
Yeah.
refocus on this hearing, you were talking about people who are bringing alcohol and consuming it. We were talking about a liquor licensee
I got that.
who has authority to sell.
I say if there's any inspection there. In this case here, they weren't shut down for any reason, were they?
No.
Okay. And whenever they were discussions, they were compliant. What is the function of the Department of Transportation with regard to this? Do you know?
It was special events, DOT.
So if you're going to go in a public thoroughfare, you need something from the Department of Transportation, correct?
Yes, and zoning.
So when you close down Washington Boulevard for an Oriole game, Department of Transportation comes in, correct?
Yes.
If you were on a licensed premises, you don't need anything from the Department of Transportation. If you know, if you don't know, you don't know.
I'm not sure if that's true.
I have nothing further.
Okay.
Just,
Anything else you want to add?
no, just real quick, because there's so many.
All right, listen for a minute. Can you raise your right hand, sir, please?
I do. Stefan, S-T-E-F as in Frank, A-N, Popescu, P-O-P-E-S-C-U.
Now, you were there on opening day, is that correct?
That is correct.
Did you met with the inspector, and you remember seeing her, or no?
I do, yes.
Okay. And along with that, you have a license that covers outdoors, is that correct?
That is correct.
And the situation is, did you ever talk with the Department of Transportation concerning any of this matter?
We tried.
And they wouldn't respond to you, is that correct?
Multiple phone calls, multiple times going downtown, multiple emails, very little ability to understand what exact permits we needed for what.
And you were at this point here, once there seemed to be some confusion, I think once you were told you put everything inside and they didn't close you down, is that correct?
Correct. My understanding, the only confusion was the band outside. There was no confusion on our end for the liquor license for the outside area. So we did not understand that at all from DOT, what the inspector was explaining to us at the day of about the outside bar.
You understand that when it's not opening day, that outdoor service means people seated at tables, though, right?
Actually, that day I received multiple answers from
I'm not
DOT.
talking about 45,000 people. I mean, just on a normal, like today.
Does a high top count or not
And
count?
the problem is that you're saying that people are seated. He was told if you're seating at a high top table, it doesn't qualify, which is not correct.
I'm not sure that's true.
No,
If
yeah, because
patrons
it
are
says
seated,
table. It
they
says
can be
table.
served. Right.
And then he was told he had to have the tables against the wall, which is not correct. But I mean, I don't want to get into
I
that.
just want them to understand that you can't have people wandering through and just
Yeah.
standing around and drinking. I don't know. It might be
Correct.
hard to control on opening day, but other days, I'm talking.
Yes, yes. I understand the purpose of the outdoor seating, yes.
And he had security, and then they maintained that. I'm just going. My final argument is that they were licensees shall operate their establishments to avoid disturbing the peace, safety, health, or welfare of the community. That didn't happen. In this case, there was opening day. There was thousands of people. They didn't disturb any community there. You know, and thank God they won, because they're not going to have 45,000 people anymore. Open container and consumption. There's nothing to. I understand the severities, but if you were seated at a table drinking and eating, and you went inside with the drink in your hand, you could still come outside with it. You don't have to put it down anywhere. That's my argument, because there seems to be a lot of confusion with this thing. And the one-day extension, as I understand it, now we can ask for an opinion, only has to do when you're extending whatever license you have beyond the licensed premises. And it's not what happened here. Okay.
Okay. Commissioner, is that a question? No questions. All right, thank you. Thank you. On the basis then of the materials contained in the charging documents, the proffer from counsel and the testimony received, I find a violation of Rule 3.12, General Welfare, and a violation of Rule 4.071, Open Containers, on March 31, 2025, considering all the circumstances, and impose nominal fines of $50 as to each and give them 30 days to pay.
Based on materials and testimony provided today, I also agree with the chair's findings, violation of Rule 3.12, General Welfare, with a fine of $50, violation of Rule 4.071, Open Containers, and illegal possession and consumption of alcoholic beverages, with a fine of $50.
Based on the violation of 4, proffer made by counsel and testimony given today, also find a violation of Rule 3.12, General Welfare, and a violation of Rule 4.071, containers and illegal possession and consumption of alcoholic beverages on March 31st, 2025. Also agree with the nominal fine of $50, violation 3 days of pay.
Russell?
Exhibits for the record, Board Exhibit 1, violation report, Inspector Case, and 2 through 6 photos.
Thank you. Good luck, sir.
I'll leave you with no hookah.
I just want to say thank you very much, the board and the inspector, for being professional throughout the entire process. I do appreciate it.
Thank you. And I should have noted you have no prior violations. I hope you don't have any in the future, so thank you. And I hope that they're on a winning streak, but I don't know. Right.
There being no further business before the board is in recess until Thursday, June 5th, 2025 at 10:30 a.m. And just a reminder, the hearing will be held in the new hearing room located at 200 St. Paul Place, Suite 2300. We are adjourned.
Thank you.